Recording in progress.
Good morning, colleagues and everyone on the platform. I guess we may start. It's 9 o'clock now. I've seen a couple of members have logged in, and also I've noticed that DOT family have logged in as a group. We are all welcome and good morning. Thank you very much. I will suggest that we start, but I will ask the committee secretary just to finish us with the apologies, if there are any. I know one that was registered in our last meeting, Honorable Hensinger, he did indicate that he won't be available. Other than that, let me check over to you, ma'am, if you can just take us through any apologies.
Good morning, Chair. There was an apology from Mr. Winsinger, as you've indicated. No other written ones were received. And there are currently 4 members in the committee. In terms of the process, if the committee is going to agree on the clauses as it proceeds, we need the 6 members present.
For now, I think we're not doing that. We are hearing a summary from the advocate who have responded, and then after that, our engagement previously as a principle is that we will take note what would be presented. Then after the completion of the clauses, we had then, as the political parties have been allowed ourselves to go to our principals, come back then and adopt the bill. So this process is not intending to adopt any clauses. But I would then be guided by other honorary members if the understanding is the same. I would say by show of hand. Honorable Lerato, over to you, ma'am, and good morning.
Good morning, Chairperson. Yes, Chair, I totally agree with you on the principle that you have just outlined to us, that we must go through the bill and then we will come back as political parties, whether we agree or not. And then on the apologies, Chair, Honorable Noluchungu, she's trying to log in, but I think that she will log in because of due to the network where she is currently right now, she cannot log in. Thanks, Chair.
Thank you, Honorable Kito. Honorable Kumar, I see your hand. Over to you, ma'am.
Morning, Chair. I actually wanted to agree to what we have said earlier on, and I don't want to say my hand was up before then, Lerato, because I'll be sounding like you are no longer friends, but myself and Honorable Lerato were big friends. No, Chair, you are quite correct that we are only looking at the bill. We actually finalizing what advocate has been alluded to on our meeting, on our previous meeting. That is our understanding, Chair. Thank you.
Thank you very much, honorable members. That will give us then, shall we proceed and may I hand over to advocate to take us through from our last clause, which was, I think, is 43, if I'm not mistaken.
Morning, Chairperson and members. Chair, I'm just quickly getting my screen ready here. Okay, Chair, we left off looking at clause 44, and we are on clause 45 today, which is the formalities of inspections. The members will see that the formalities of inspections is a new addition. It expands and it sets specifics regarding the inspections rather than the general terminology of the Principal Act. There were comments here from the Western Cape government. That was the only comment that was received on this specific clause. The department did not agree with it. Going through the clause, formalities of inspections, section 45(1). During any search, only a female railway safety inspector or female police officer may search a female person. Only a male railway safety inspector or male police officer may search a male person. Sub 2, a railway safety inspector who removes anything from premises being searched must A, issue a written receipt for it to the owner or person in control of the premises in sufficient detail to identify each specific item so removed, and B, return it in good order as soon as practical after achieving the purpose for which it was removed to the person from whose control it was taken, unless it is to be used as evidence in any subsequent proceedings, in which case the railway safety inspector must, in writing, inform the person from whose control it was taken of that fact. Sub 3, a person who submits any information to a railway safety inspector or makes any statement to him or her may do so orally, and he or she may A, indicate to the railway safety inspector that he or she claims confidentiality in respect of any information statements are provided, and B, provide the railway safety inspector with an explanation why the information or statement is confidential. Sub 4, a railway safety inspector must A, consider any claim and explanation contemplated in subsection 3, B, notify the person who claims confidentiality whether or not that information or statement will be treated as being confidential, and C, if the railway safety inspector considers such information to be confidential, keep such information confidential unless 1, such information is already in the public domain, 2, the railway safety inspector is ordered by a court of law to disclose such information, or 3, the disclosure complies with the Promotion of Access to Information Act or the Protection of Personal Information Act. So, Chair, that is clause 45. Going to clause 46, and Chair will just stop me if there is a hand coming up, Chair, because I can't see the hands from my side.
No, you won't be able. I was just about to say, advocate that. Let's proceed. We'll see by show of hands if there are any inputs that members want to do. You may proceed. Thank you very much.
Thank you, Chairperson. Our next clause is clause 46. It is the duty to assist railway safety inspector. The Principal Act had this under section 34. So I'm just displaying that section for members to also see. It was a much shorter clause in the Act. There were no comments on this clause in the submissions. Duty to assist, 46(1). When a railway safety inspector enters any property as contemplated in section 43 or 44, the operator, owner, or manager and each employee working there must, subject to subsections 2, 3, and 4, assist the railway safety inspector by furnishing him or her with answers to questions and by providing him or her with any facility that the railway safety inspector may reasonably require for purposes of the inspection. Sub 2, a railway safety inspector or a police officer who is assisting a railway safety inspector in terms of section 44(8) for purposes of entering or searching premises under sections 43 and 44 must, before questioning anyone, A, advise the person to be questioned of the right to be assisted at the time by a legal practitioner, as well as of his or her rights contemplated in subsection 3, and B, allow that person reasonable opportunity to exercise those rights. Subsection 3, a person questioned by a railway safety inspector must answer each question to the best of his or her ability, but such person is not required to answer any question if the answer may be self-incriminating. Sub 4, a railway safety inspector must, prior to questioning a person in terms of subsection 1, in the presence of that person in writing, record the date, time and place and the name of that person who has been advised of his or her rights in accordance with subsection 2A. Chair, then going to clause 47, which is the powers of the railway safety inspector to deal with unsafe conditions. This was dealt with under section 36 of the Act. As we'll see again, it was a very short section in the Principal Act. We received comments on this clause from the Western Cape government. And it was only from them that there was input received here, where they again focused on certain words that they require clarity. Going to the clause 47.1, subject to subsection 3. If the railway safety inspector has good reason to believe that a condition or activity is a threat or might be a threat to safe railway operations, the railway safety inspector may submit a written report to the affected operator stating the reasons for believing that the condition or activity is a threat or might be a threat to safe railway operations, and allow the person a reasonable opportunity to respond to the report. Sub 2, if the railway safety inspector is not satisfied with response from the operator, or if the operator fails to respond to the report, the railway safety inspector may, in writing, issue a directive, A, restricting or suspending that condition or activity or the railway operation itself, B, placing a condition on the continuation of that activity, or C, specifying what action must be taken within a specified time by that person to remove the threat. Sub 3, if there is a threat to safe railway operations that poses an immediate or imminent risk of serious danger to persons, property, or the environment, the railway safety inspector may, despite subsections 1 and sub 1 and 2, after engaging orally with the operator or person who ostensibly is in charge of the relevant premises or rolling stock, issue a directive in writing as contemplated in subsection 2. Sub 4, subject to section 57.3, any person who fails or refuses to comply with the directive within the period specified in the directive is guilty of an offence, unless an appeal has been lodged in terms of subsection 5, which has not yet been finalised. Subsection 5, any person who is aggrieved by a directive issued in terms of subsection 3 may lodge an appeal contemplated in section 54. Sub 6, an appeal lodged as contemplated in subsection 5 does not prevent a person from obtaining urgent relief from a competent court of law. And then sub 7, a railway safety inspector may issue compliance notices and penalties contemplated in section 67. So Chair, then just to look at the Western Cape, the department noted their comments, did not accept their comments because the words have literal meaning in the context. They raised concerns regarding the use of condition, activity, as well as a reasonable opportunity. Chair, I see there might be a hand, so I will pause here.
The Honorable Jobe, over to you, sir. Honorable Jobe.
Thank you very much, Honorable Chairperson. Greetings to you and the members and to the staff of the Portfolio Committee and the officials. Chairperson, I'm trying to check, when you check subsection 1 and subsection 2 and 3, there's a lot of threat. I'm trying to check that there is no other way that they can use instead of using the whole sentence, the number 1 and number 2. Threat. I'm trying to check that one, Chairperson. Thank you very much, Honorable Chair.
Thank you, Jobe. Advocate, are you in a position, or it's one of those things that we would then make our pronouncement as we conclude in terms of the clauses at a later stage?
I think the department can assist here. I do think the use of the word threat is accepted in terms of, we'll see in the Principal Act, they also use the word threat. It could be a threat, danger, it's a wording, so it might be semantics, or the department can just clarify if they need a continuation of that word for regulation purposes, Chair.
I think it should be proper that let me allow the department. Mr. Ngako, I thought you are the best person to take us through. Thanks.
Good morning, Chair, Honorable Chair, and good morning to honorable members. Chair, we are obviously aligned with regard to what the advocate have said, because for us, the word, we thought it was very relevant in this context, in terms of really being a threat to railway safety operation. And like the advocate have said, it's something that was even in the Principal Act, and it really continues as such. Thanks. Unless there is another word that maybe is being suggested for us to consider, but at this stage we will remain with what we have put in the legislation, in the bill. Thanks, Chair.
I think that explanation suffices. Honorable members, they will think about it and find a better word if we think that it's a need to take it out. It does impact on the Principal Act, however, but I think let's flag it as Honorable Jobe. When we come back to conclude and finalize the bill, then we can confirm, having also had the explanation in terms of the rationale of the choice of word. And I guess we may proceed because we were just seeking a clarity. Thank you very much, honorable members. Back to you, Advocate, you may proceed.
Thank you, Chairperson and members. We are now entering Chapter 7, Railway Occurrence Reporting and Investigations. The clause is Clause 48 on railway occurrences. Members would have seen here that this would correlate with the Principal Act, which is really a one-liner and quite short on railway occurrence reporting. But it's also, if we look at the railway occurrence reporting in the Principal Act, that's more linked to our Clause 49, which we've dealt with, or which we will be dealing with after this one. The new clause seeks to define how the definition of occurrence is regulated. And we will see here also there were comments on this particular clause from the Western Cape government. And it was only that one comment on the clause from them, and their members will see the department's response. So we'll proceed to Clause 48. 1. The Minister may prescribe a railway accident or incident as a railway occurrence. Sub 2. An operator must, as soon as practical, after a railway occurrence, A. secure the scene of the railway occurrence. B. Prevent the movement or removal of rolling stock or infrastructure which has a direct or indirect bearing on the railway occurrence unless 1. Such rolling stock or infrastructure must be moved in order to provide medical help to any injured person, or 2. A full and accurate record of all salient facts relating directly or indirectly to the railway occurrence has been made, and any evidence or other relevant material has been secured for later inspection, analysis, or investigation. And C. Record the names and contact details of all persons who may provide evidence or information that has a direct or indirect bearing on the railway occurrence. Sub 3. A person who moves or removes rolling stock or infrastructure at the scene of a railway occurrence in contravention of subsection 2B is guilty of an offence. Sub 4. A person in control of the scene of a railway occurrence, which is the subject of an investigation, must A. allow the person conducting an investigation in terms of this act to remove any articles or objects pointed out by an investigator contemplated in sections 51, 52, and 53. B. Allow the inspection of the documents requested by that investigator, including the making of copies thereof. And C. Furnish that investigator with any information which is under that person's control. So, Chair, going to the comments, Western Cape government indicated it's not clear what was meant by infrastructure, which has a direct or indirect bearing on the railway occurrence. They proposed clarification, and the department indicated that it is a legal requirement not to tamper with the scene of the occurrence. Members will see the same as normally provided for in any vehicle accidents, where there is critical injuries or loss of life, and normally you can only remove those items or the scene once it's been recorded and get it out of the way so that the traffic flow continues. It is similar proposals here for the railways. And in the inspection reports, they do look at the material of the track as well if there is an incident to determine if there was any cause there linking to the occurrence. So, Chair, that is clause 48. Moving to clause 49, which is the reporting of a railway occurrence. Again, this is in the Principal Act, section 37. Members will see here there were comments from PRASA, general comments on vicarious liability, and on clause 49, read with 57.2. And it was the only comments that the committee received for this specific clause. The department did accept the comment, but let's go through the clause first. 49.1, an operator must report a railway occurrence to the regulator in the time, manner, and form prescribed by the minister. Sub 2, an operator who fails to report a railway occurrence as contemplated in subsection 1 is guilty of an offence. So members will see here it creates a new criminal offence according to PRASA's comments on the failure to report, and they do say they recognize the need for this, and it's undesirable to create strict liability unless there's demonstrable intention to frustrate the compliance. And that is the aspect of the input that the department agreed with, indicating that negligence as required standard is recommended, and the department there proposed a amendment here in 49.1 so that it would then read an operator who negligently fails to report. Sub 2, 49.2, not 1, an operator who negligently fails to report. So that is the proposed inclusion from the department following the comment from PRASA. Chair, then our next one is clause 50, categories of railway occurrence investigations. This is similar to section 38, which was in the Principal Act. There were no comments on this specific clause received. 50 sub 1, for purpose of this chapter, the minister must prescribe the following categories of investigations. A major investigation to be conducted by an independent investigator in accordance with section 51. And B, a standard investigation to be conducted by the relevant operator in accordance with section 52. Sub 2, for purposes of categorization, the minister must take into account all relevant matters, including A, loss of life or potential life-threatening injuries to persons, B, minor injuries to persons, C, the extent of the disruption of the normal flow of railway transport, D, the frequency of railway occurrences reported by the same operator, E, the frequency of railway occurrences involving the same rolling stock, infrastructure or station, F, the extent of ancillary damage caused to property belonging to persons other than the operator as a result of the railway occurrence, G, the extent of damage to rolling stock, infrastructure, or a station owned by the operator, and H, any other matter relevant to the investigation of railway occurrences. Chair, then we get to clause 51, which we've just heard some reference to, and this describes what investigation. The Principal Act did not have a similar section describing a major investigation. There were comments on this clause from the Western Cape government. The department did not agree with the comments. They did indicate further response there to 50 sub 7B. But in the main, they did not agree with the comments there from the Western Cape government. Going through the clause, 51.1, the minister must, in the event of a railway occurrence requiring a major investigation contemplated in section 50 sub 1A, by notice in the Gazette, appoint an independent institutional panel of persons in this section referred to as the investigator, who have no direct or indirect connection with or interest in any person or operator involved in the railway occurrence to conduct an investigation on that particular railway occurrence. Sub 2. The notice contemplated in subsection 1 must contain A, the name of the institution or the names of the persons serving on the panel referred to in that subsection, B, the terms of reference of the investigation, C, the date by when the investigator's findings on the causes and circumstances of the railway occurrence and recommendations relating thereto must be submitted to the Minister, D, a reference to any provisions of the Commissions Act that may apply to the investigator with the necessary changes subject to such modifications and exemptions as may be specified in the notice. E, measures for the protection of personal information of any person directly or indirectly involved with the railway occurrence. And F, any other matter which the Minister may consider necessary for the expeditious and effective finalization of the investigation. Sub 3. The Department must provide all necessary financial, administrative, logistical, and legal support to the investigator. 4. The investigator may submit interim reports to the Minister. 5. The mandate of the investigator ends upon submission of the final report to the Minister, upon which the investigator's duties and authority comes to an end. 6. The investigator may not publish any report or disclose any information to the public without the authorization of the Minister, unless it is demonstrably in the interest of justice or of the public to do so. 7. The Minister must, after receipt and consideration of the investigator's final report, without undue delay, A, publish the report in any manner that the Minister may, in the manner that the Minister considers fit, B, as far as may be practical, give effect to the recommendations by the investigator, and C, if recommended by the investigator, refer the report and any supporting documents or other evidence accepted by the investigator in his, her, or its investigations or other evidence, investigation to any regulator or prosecutorial entity. Sub 8. Subject to subsection 9, this section does not prevent an operator or the regulator from conducting its own internal investigation into a railway occurrence, but A, the investigation and the investigator contemplated in subsection 1 at all times and in all respects take precedence over an internal investigation, including in respect of access to eyewitnesses and evidence. Sub B, such an internal investigation may in no way interfere, hinder, or impact on the investigation contemplated in subsection 1. C, the investigator may instruct the operator to provide full and unfettered access to any records produced by or other evidence in the possession of the operator relating directly or indirectly to the railway occurrence. D, the person conducting an internal investigation may not conceal, alter, or destroy any records produced by or other evidence in the possession of the operator relating directly or indirectly to the railway occurrence. E, the person conducting an internal investigation must confidentially inform the investigator or any information or records he or she comes into possession of, or of which he or she becomes aware if that person suspects or knows that the investigator is not aware of such information or record. F, the findings, conclusions, recommendations, or results relating to the investigation may not be released into the public domain until the report by the investigator has been published as contemplated in subsection 7A. The Minister may, if he or she considers it necessary in writing, prohibit an operator or the regulator from conducting an internal investigation contemplated in subsection 8. 10. Any person who willfully interrupts the proceedings of an institution or panel appointed in terms of subsection 1, or who willfully hinders or obstructs any such institution, panel, or investigator in the performance of its, his, or her functions is guilty of an offence. 11. Any person who willfully fails to comply with subsection 8B, C, D, E, or F is guilty of an offence. Considering the input from the Western Cape, they suggested that it's recommended that the wording be revised to afford the Minister the discretion to request interim reports from the investigator. The Department did not agree with that suggestion for subclause 4. Then looking at subclause 51.7a, they suggested that it's recommended that the clause be aligned with the proposal in the column to the left, and that was a column that the Western Cape provided. Bottom did not agree with that. For sub B, they recommended the deletion of the words "as far as may be practical." The department's response was that the investigators' report are recommendations, not binding directives, hence the use of "as far as practically possible." 51.8c recommended that the scope of the clause be narrowed. The department did not agree with that. So, Chair and members, that was clause 51. Moving on to clause 52, the standard investigation, which is the other type of investigation that the minister may call for. And this is again in line with section 38 of the Act. Again, there were input here from the Western Cape government. And the input on this specific clause 52 sub 4 was agreed to by the department. Reading the clause 52.1, in the event of a railway occurrence requiring a standard investigation contemplated in section 50 sub 1b and subject to subsection 4, an operator must conduct an investigation in respect of that railway occurrence. Subsection 2, the operator must furnish a railway occurrence investigation report to the regulator in the prescribed time frame, manner and form. Subsection 3, the regulator may, after consideration of the railway occurrence investigation report, require the operator to assess and report on the impact of the implementation of the recommendations made by the operator. Subsection 4, in the event of a railway occurrence requiring a standard investigation as contemplated in section 51b and involving more than one operator, all operators involved must conduct an individual investigation in accordance with subsections 5 and 6. Subsection 5, the operators contemplated in subsection 4 must, within 60 days from the date of the railway occurrence, separately conduct their respective investigations, and every operator must, upon completion of its individual investigations, furnish a railway occurrence investigation report to the regulator in the prescribed time frame, manner and form. Subsection 6, if after consideration of the separate reports, A, the regulator has reason to believe that the operators have colluded in conducting their respective investigations and in submitting the reports, or have not submitted reports which accurately reflect the details of the railway occurrence or sufficiently address the issues impacting on railway safety, the regulator must request the minister to exercise his or her powers contemplated in subsection 7. Or B, the regulator is satisfied that reports accurately reflect the details of the railway occurrence and sufficiently address the issues impacting on railway safety. The regulator must decide whether further action must be taken, and if so, the regulator may 1, release the reports received to all operators concerned in order for them to provide the regulator with comments, but only if the regulator allows the operator or operators concerned to submit replies to those comments. 2, request the minister to exercise his or her powers contemplated in subsection 7, or 3, subject to this act, take any steps provided for in law if he or she considers it necessary. Subsection 7, the minister may, in his or her discretion, A, after receiving a request from the regulator as contemplated in subsection 6a, reject an investigation report by an operator if the minister regards that investigation to have been inadequate. Or B, instruct an operator not to conduct any further investigations if the minister considers it appropriate to order an investigation contemplated in section 51 or 53. So members will see here the recommendation by the Western Cape government was to revise the wording so that it is clear that the investigations are to be separate, and the department agreed to that proposal. Moving on to clause 53, the Commission of Inquiry. This is a new clause that we did not see in the Principal Act, and there were no comments on this specific clause received from the public. 53, despite anything to the contrary in this chapter, the minister may, in his or her sole discretion, request the President of the Republic to appoint a Commission of Inquiry in terms of Section 84, sub 2F of the Constitution of the Republic of South Africa of 1996. And in the event that an investigator has already commenced any other investigation in terms of this part, the investigator must immediately, upon publication of a proclamation in the Gazette by the President, establish a Commission of Inquiry. Establishing a Commission of Inquiry, terminate that investigation and submit all evidence or other relevant information in his or her possession to that Commission of Inquiry. So, Chair, that's the end of Chapter 7. We are moving to Chapter 8, which deals with the various types of appeals that are available. Clause 54 is the appeal to the CEO. If we look at the Principal Act, it was dealt with in terms of Section 43. Where the heading was the appeal to the Chief Executive Officer against a decision of the Railway Safety Inspector. On this clause, there were comments from COSATU, and there were comments from PROSA. It was only those two bodies that provided comments for this clause. Clause 54(1). Any person other than an employee of the regulator or a supplier of goods or services to the regulator whose rights or legitimate expectations are adversely affected by a decision or directive of a railway safety inspector or any other employee of the regulator, taken on behalf of the regulator in the exercise of any power or performance of any duty in terms of this Act, may, subject to subsection 7, lodge an appeal against that decision with the CEO. Subsection 2, an appeal lodged in terms of this section must A, be lodged within 30 days from the date on which the decision was made, known or of the directive issued by the railway safety inspector or employee, as the case may be, or such later date as the CEO permits, and B, set out the grounds of the appeal. Subsection 3, after considering the grounds of the appeal and the railway safety inspectors or the employee's reason for the decision, the CEO must, within the prescribed period, A, confirm, set aside or vary the decision, or B, substitute the decision of the railway safety inspector or employee with the decision of the CEO. Sub 4, the CEO may not delegate his or her duties or powers in terms of this section to an employee of the regulator below the rank of head of a division. Subsection 5, the CEO must keep a record of an appeal lodged in terms of this section and must, A, on request and at no charge, provide a party to the appeal with a copy of the record, and B, submit the record to the Transport Appeal Tribunal if an appeal is lodged with the tribunal as contemplated in Section 56. Sub 6, in instances where A, it is unclear whether a decision was taken by the CEO or an employee of the regulator, B, the CEO or any person to whom he or she has delegated this function has a conflict of interest or is for any other reason not able to appear or to hear an appeal in terms of this section, or C, a hearing of the appeal is urgent, an appeal may be lodged directly with the Board Appeals Committee for purposes of a hearing contemplated in Section 55. Sub 7, an appeal lodged as contemplated in subsection 1 does not prevent a person from obtaining urgent relief from a competent court of law. Chair, just looking at the comments here from COSATU, but they were concerned that subclause 51(1) would deny employees of the regulator rights to appeal to the CEO. The department's response to this was that the labor law provides for such situations. And then in terms of process comments, there were general comments on the appeals, which the department responded to, that the procedural elements of an appeal are universal and that they have a suspensive effect on the decision. Chapter 8 of the bill outlines the specific appeal process in detail. And then considering the specific comments on the this clause 54, In light of the role of the CEO as the regulator and immediate supervisor of the inspectorate, it's not desirable for the CEO to hear appeals from the inspectorate, as there is an appeal conflict of interest. The department agreed, and it's already provided for in clause 19 sub 3 and 4. In terms of the conduct of appeal by CEO, not desirable if, however, it's intended to ensure a speedy resolution. The department disagreed, and they indicated that the speedy resolution is required. CEO has discretion who advises him or her prior to the independently applying his or her mind to the appeal. So, Chair, then we move to clause 55. 55 is the appeal to the Board Appeals Committee, which is the second tier in terms of processing appeals linked to the railway safety regulators' decisions. We'll see here it was provided for in section 44 of the Principal Act. And there were comments received on this clause from Chemicals Association, which the department agreed to and indicated it's already provided for in clause 19 sub 3.4. And then comments again from CASATU, where the department's response was that the labour law will apply. And then comments from PRASA regarding the conflict of interest concerns. And then comments from the Western Cape government regarding the composition of the Board Appeals Committee. So members will see those were the comments received on clause 55. The Chair then reading the clause 55.1. Any person other than an employee of the regulator or a supplier of goods or services to the regulator whose rights are adversely affected by a decision of the CEO and the exercise of any power or performance of any duty in terms of this Act or in respect of an appeal contemplated in section 54 may lodge an appeal against that decision with the Board Appeals Committee as prescribed. Subsection 2. Such person must lodge the appeal and set out the grounds of the appeal within 30 days from the date on which the decision of the CEO was made known, or such later date as the chairperson of the board permits. Sub 3, the board must consider and finalize the appeal within the prescribed period, and after considering the grounds of appeal, the reasons for the decision of the CEO and the CEO's reply to the grounds of appeal, the board may A, confirm, set aside, or vary the decision, or B, substitute the decision of the CEO with the decision of the board. Sub 4, the board may delegate its duties or powers in terms of this section only to a Board Appeals Committee, and if an employee of the regulator serves on such a committee, he or she must recuse him or herself from the committee for any appeal hearing. Sub 5, the board must keep a record of an appeal lodged in terms of this section and must A, on request and at no charge, provide a party to the appeal with a copy of the record, and B, submit the record to the Transport Appeal Tribunal if the matter is appealed to that tribunal in terms of section 56. Subsection 6, the board may, for purposes of this section, appoint a standing Board Appeals Committee chaired by a member of the board, together with 2 persons who are not members of the board or employees of the regulator, of whom at least one must be a legal practitioner, and the decision of the Board Appeals Committee is the final decision of the board. Subsection 7, in instances where a member of the Board Appeals Committee has a conflict of interest, or is for any other reason not able to hear an appeal in terms of this section, or B, a hearing of the appeal is urgent, an appeal may be lodged directly with the Transport Appeal Tribunal as contemplated in section 56. Sub 8, an appeal lodged as contemplated in subsection 1 does not prevent a person from obtaining urgent relief from a competent court of law. Chair, then just the focus here on the PRASA comments, where the department's response was the board may, for purpose of this section, appoint a standing Board Appeals Committee with 2 persons who are not members of the board or employees of the regulator, hopefully therefore dealing with the possible conflict of interest concerns. Western Cape comments, again, the Western Cape indicated that it's unclear whether or not the intention is to refer to the board or the board appeals committee, and the department indicated here it's a full board unless it is delegated. And then suggestion here for 55.3 to reconsider the clause and amend as may be appropriate. The department noted the comment, and their response was that the clause deals with appeals to the board appeals committee. 55 sub 6. They recommended that the clause be amended to show that only the member of the board will be the chairperson, and the other two people on the appeals committee will be ordinary members, not co-chairs. The department did agree to consider the change here of the wording for that specific subclause. Members, then moving to clause 56, which is appeals to the Transport Appeal Tribunal. This is a new one. We did not find similar appeal process in the Principal Act. For this clause, we received comments from PRASA, and it was only this comment that I have on the screen here received from PRASA. Going to the clause 56.1, a person who is aggrieved by a decision regarding an appeal in terms of section 55 may, in terms of section 12 of the Transport Appeal Tribunal Act, lodge an appeal with the Transport Appeal Tribunal against that decision. Sub 2, any appeal lodged in terms of subsection 1 must comply with the Transport Appeal Tribunal Act and any regulations promulgated thereunder. So, Chair, by using this reference, the time periods within the appeal must be lodged, as well as by when the decisions must be made or how the Transport Appeal Tribunal may come to a decision, is catered for within the Transport Appeal Tribunal Act. Chair, then we are done with the appeals chapter and we move to chapter 9, which is general and miscellaneous. Under this one, we'll find our first one, which deals with part A on offences and penalties. We see here this was chapter 10 in the Principal Act, and clause 57 on offences and penalties is similar, if we read it here in the Principal Act, to sections 45 as well as 45 capital A, where they split these two. There were comments on clause 57 from PRASA. In general, and specific to the later section 59. And it was only the one comment here from PRASA that we had for offences and penalties. So reading the clause 57.1, a person who commits an offence in terms of sections 30 sub 10, 36 sub 4, 43 sub 3, 44 sub 12, 47 sub 4, or 48 sub 3 is liable on conviction to a fine or imprisonment for a period not exceeding 15 years, or to both a fine and such imprisonment. Sub 2, a person who commits an offence in terms of sections 34.3, 41.4, 49.2, 51.10, or 51.11 is liable on conviction to a fine or imprisonment for a period not exceeding 5 years, both a fine and such imprisonment. Subsection 3, no person may be prosecuted in respect of an offence contemplated in subsection 1 or 2 if the regulator has given notice that it's going to issue a compliance notice or penalty as prescribed in terms of section 67 or has done so. And in the event that a prosecution is nevertheless instituted, such person may raise a plea that he or she was already convicted in respect of that charge. So members will see here in terms of the comment that the department agreed to, in terms of that section 59, the department agreed that they to replace the word used all to be replaced by appropriate. So it's not going to be all steps that were reasonable, but appropriate steps. Then, Chair, moving to clause 58, which is offences in relation to employer or principal. If we look at the Principal Act, this was dealt with in section 48. There were comments here from PROSA. The department did not agree with the general comments there, indicated that the employer must also bear responsibility. And then on the specific clause, it was that response in terms of the general aspects. Going to the clause 58, an employer or principal is liable to conviction for an offence in terms of this act if an employee or agent of that employer or principal commits such an offence with the express or implied permission of that employer or principal, irrespective of whether that employee or agent has been convicted in respect of that offence. Chair, then going to clause 59, which is the liability of a director, trustee, or member of a juristic person, and Principal Act catered for this in terms of section 49. We do have comments here again from PROSA, but this is the department's response is the same as for the previous clause regarding the all and appropriate steps. Reading the clause 59, a person who is or was a director, trustee, or member of a juristic person at the time of the commission by that juristic person of an offence in terms of this act is guilty of that offence and is liable on conviction to the penalty specified in respect of that offence if that offence resulted from the failure of the director, trustee, or member to take all steps that were reasonable under the circumstances to prevent the commission of the offence. So members will recall the department's proposal here is to change the all to appropriate. Then moving to our next clause is clause 60, which is the inquiry in respect of commission and award of damages. And the closest to this clause we will find in both of these sections 46 and 47 of the Principal Act. There were comments linked to this clause from PROSA, where the department indicated that it is a policy issue, and that was the only comment received on this clause. Clause 60, sub 1, where a person is convicted of an offence in terms of this act, and A, another person has suffered harm or loss as a result of the act or omission constituting the offence, or B, damage has been caused to property or to the environment, a court may, in the presence of the convicted person, inquire without pleadings into the harm, loss, or damage and determine the extent thereof in the same proceedings. 1, at the written request of the person who suffered the harm or loss, or 2, at the written request of the minister or the regulator in respect of the damage caused to property or to the environment. Subsection 2, after making a determination in terms of subsection 1, the court may A, award damages for the loss or harm suffered by the person referred to in subsection 1A against the convicted person. B, order the convicted person to pay for the cost of any remedial measures to be taken. Or C, order that the convicted person implement remedial measures. Moving forward out of the offences and penalties, still under the same chapter, but Part B. Part B deals with the regulations and notices. Members will see there's quite a few different types of regulations that can be issued in terms of the bill and the act. And Clause 61 deals with the general powers of the minister to regulate. In terms of the Principal Act, we look at section 50. And then just for members to note here that the bill does not specify that the minister must, as per sections 50 sub 3D of the Principal Act, table the regulations in the NA and NCOP on request of the committees. So in terms of the bill, that specific requirement is not provided for. There were comments on clause 61 from the Western Cape government. And it was only that input from them received for this clause. Clause 61.1, the minister may, subject to subsections 2 and 3, make regulations by notice in the Gazette regarding any matter required or permitted to be prescribed in terms of this Act, including A, any other place as a station or forming part of a station as contemplated in paragraph B of the definition of station in section 1. B, any limitation on the board's power contemplated in section 20 sub 1 in respect of delegating any of the board's functions, duties, powers, or obligations. C, matters provided for in section 61 to 67. Or D, generally all matters that are necessary to be prescribed for the effective administration of this Act. Sub 2, any regulation or notice made in terms of this Act may provide that A, the contravention thereof or failure to comply therewith is an offence, and B, a person convicted of that offence is punishable with a prescribed fine or a term of imprisonment not longer than the period so prescribed. The prescribed fine may not, at the time of publication of that notice, exceed the amount prescribed in respect of 1 year of imprisonment, determined in accordance with the Adjustment of Fines Act. Subclause 3. The minister may request the regulator to advise on any draft regulations for his or her consideration, and any stakeholder may submit representations to the minister on such proposed regulations. Sub 4, the minister must, before making any regulations in terms of this Act or issuing a notice in terms of section 67, A, publish a notice in the Gazette, 1, setting out the draft regulations or draft notice as the case may be, and 2, inviting written comments to be submitted to the proposed regulations or notice, specifying an address to which and a date before which the comments may be submitted, which date may not be earlier than 30 days after publication of the notice. B, implement further steps, if any, which may in his or her opinion be appropriate to bring the content of the proposed regulations or notice to the attention of interested persons, and C, consider all comments received on or before the date specified in paragraph A3. 5, when making regulations or issuing a notice, the minister must take into account A, the impact of such regulations or notice on railway safety and operations, B, the balance between the need for safe railway operations and the economic viability of new measures to achieve safe railway operations, and C, whether the measures must apply to both traditional railway operations and rapid rail operations. The members will see here the comments proposed by the Western Cape government. The first one on 61.1a, it's recommended that the clause be amended to make its meaning clear, and further the word station should be in bold. The department agreed to this. In terms of 61.3, the recommendation was to revise the clause. The department's response was that the ultimate promulgator of the regulation is the minister. There is nothing wrong in the bill indicating some of the paths the minister would have to follow in getting the draft regulations, including using the RSR as one of the paths. 61.4a, the suggestion was to consider amending the clause to provide for electronic submissions. The department agreed. The address is not limited to physical addresses and may also refer to electronic addresses. 61.5c, the recommendation is to revise the clause for the sake of clarity, as it would ensure consistency in interpretation, and the department did not agree. So, Chair and members, that is clause 61. Moving to clause 62. Here's where we get into specific types of regulations. 62 is the regulations regarding design, construction, alteration, and new operations. And looking at the Act, the section that best correlates with the provision of these regulations is section 30. On clause 62, committee received comments from the Western Cape government, general in dealing with persons with disabilities, and then clauses specific to section 62. And there were also comments from the RSA cluster group on this specific clause. And those were the two comments received for clause 62. Going through the clause, 62 sub 1, the minister may make regulations relating to the design, construction, alteration and new operations of railway or railway operations that have an impact on safe railways or railway operations, including regulations regarding A, the types of new or proposed construction or operation which require the regulator's approval, B, the criteria requirements to be met for obtaining the regulator's approval, C, the procedure for obtaining the regulator's approval, including the noting of objections, D, the design, construction, manufacture, alteration, commissioning, maintenance and operation of rolling stock, infrastructure and stations, E, the safety of persons, including persons with disabilities, on board stationary or moving rolling stock, infrastructure, or at a station. F, the provision of closed circuit cameras or other monitoring devices on board a train. G, conveyance of dangerous goods by rail. H, new works and operations. I, testing and commissioning. And J, technologies. 2, the minister may determine that the national regulator for compulsory specifications, established by Section 3 of the National Regulator for Compulsory Specifications Act, or another independent safety assessor approved by the board, may, for purposes of subsection 1, D to J, assess or evaluate whether a permit holder has met the criteria or requirements contemplated in subsection 1B. Just going to the comments here, members will see that the recommendation was noted by the department, the general comments regarding the definition of persons with disabilities, but that was outside the scope of the bill. Then looking at the specific clause 62 sub 1, the department did not agree with the proposal to exclude the phrase the design, construction, alteration of railway operations. And then looking at the RSA cluster group, the department did not agree with the comments. They are covered by the standard development regulations, and the bill makes provision for the development or use of standards, but the technical details are found in the said standards. And then again on the SANS 3000, the earlier comment there on incorporation of standards. And the department does benchmark, and there's also a process for standard developments. Moving on to clause 63, and the closest one in terms of the Principal Act was section 31. Clause 63 deals with the regulations regarding infrastructure or activity affecting safe railway operations. Members would have seen here, there were comments from Kusatu and Unter regarding who would be responsible for pedestrian and passenger safety in crossings, theft, and need to bring back the railway police. In PROSA, it was comments specific to the infrastructure security under the general comments. And from the Western Cape government regarding crime in the rail environment and the roles of the stakeholders, as well as comments on security requirements, safety and security measures linked to overcrowding, again, theft. Western Cape went extensively into different types of safety and security measures in their comments. So those are the comments received on clause 63. So clause 63.1, subject to subsection 2, The Minister may, after consultation with the members of the Executive Council responsible for transport in the various provinces, make regulations on the following matters. Sub A, mines and any other excavations to the extent that the Mine Health and Safety Act and the Mineral and Petroleum Resources Development Act do not apply. B, drainage under or alongside tracks. C, any construction above, below, or adjacent to a railway track within the area used by or reserved for railway activities. B, storage of materials adjacent to the railway track. E, road level crossings to the extent that road safety legislation does not apply. And F, the unlawful occupation of property owned by safety permit holders, which renders railway operations unsafe or has the potential to render them unsafe, subject to any other law governing unlawful occupation or eviction from property unlawfully occupied. Then sub B, 2, the regulations contemplated in subsection 1 must A, affect safe railways and railway operations, and B, relate to property owned by safety permit holders. So in terms of the comments in general, the department's response is that for Kusatu and Untu, that the regulations regarding infrastructure activity affecting safe railway operations and the Sun Standard on level crossings deal with the matters raised by those two parties. For PROSA, on general comments for infrastructure security, the operators are to ensure safety and security of passengers and the assets. The department is to look at supporting this requirement through the facilitation of other relevant departments. Looking at the Western Cape comments on crime in the railway environment, the comments are noted, but the issues are dealt with in other legislation that were created to cater for other organs of state. Looking at the security requirements, again, it is noted, it's outside the scope of the bill. On overcrowding, the same response from the department. On criminal acts that impact the safety of railway operations outside the scope of the bill. On deployment of security personnel outside of the scope of the bill. And that is the end of the comments to clause 63. Chair, then moving to clause 64. There were no comments received on clause 64, and looking at the Principal Act, the section in the Principal Act closest to the regulations regarding assessment and information was section 42. Considering the clause 64.1, the Minister may make recommendations in respect of the contents, class, type, time period and format of data to be submitted to the regulator for assessment of the compliance of an operator with the provisions of this Act. And then subsection 2, the Minister may make regulations in respect of the information which the regulator must publish for public information or public consultation. Chair, then going to clause 65. 65 is the regulations regarding railway occurrence and railway occurrence investigations. Considering the principal legislation, the sections that are closer linked or most closely linked to this are the two sections 37 to 38. There were no comments received on clause 65 from stakeholders. So reading the clause, the Minister may make recommendations in respect of railway occurrences and railway occurrence investigations, in addition to those contemplated in sections 48.1, 50 sub 1, and 52.2, including A, other activities which constitute railway occurrences and the offences and penalties in respect thereof. B, steps to be taken by an operator after a railway occurrence in addition to those contemplated in section 48.2, and C, procedures, processes, and other matters relating to major investigation. Our next clause, clause 66, notice regarding fees. Considering the Principal Act, we would go to section 23 sub 2. And that is there on the screen for members. That section in the Act specified that fees may be set and collected, but never specified how the fee structure was to be determined or advertised, which the bill now does. Considering the clause, we received comments on this clause from PRASA in general regarding the funding of the regulator, as well as specific. Then we also received comments from the Western Cape government on this specific clause, as well as Transnet. Reading the clause, 66(1). The Minister must annually, by notice in the Gazette, determine the fees payable in respect of the safety permits contemplated in section 30 sub 1. 2. The Minister may, in consultation with the Minister of Finance, by notice in the Gazette, determine fees in respect of any prescribed service rendered by the regulator as contemplated in section 62(1) G to J. So considering the input received from PRASA on the funding of the regulator, the department's response was that clause 27(1) read with clauses 66 and 67(3) provide for the funding mechanisms of the railway safety regulator. Full disclosure of income is provided in the railway safety regulator's annual report. And if PRASA wants to be exempted in any way, they must use the provisions provided for in the bill for exemption. They also indicated here that holders of safety permits should pay annual fees that are to be calculated so as to collectively cover the regulator's budgetary costs for regulating holders of safety permits. Then the Minister has a discretion to issue these fees. Western Cape government comments. Comments are noted but not accepted. The consultations do take place in this process and details are addressed in the applicable regulations. Then looking at Transnet's comments and the notice regarding the fees, the department disagreed to the deletion of sub-clause 2. The National Treasury monitors the overall impact of financial burdens, including taxes, fees, charges, and monies collected by organs of state. The Minister of Finance must therefore be involved, especially since Transnet receives allocations and bailouts and appropriations legislation tabled in Parliament by the Minister of Finance. But members will see the Minister of Finance is in general included in all our pieces of legislation where fees structures are set out or arranged. We have seen most recently in the engagements that members had with SAMSA that the delays in finalizing the consultation does sometimes have an impact on the regulators. So that must just be borne in mind. Chair, then going to clause 67. 67 deals with the regulations and procedure regarding compliance notices and penalties. In terms of the comparison with the Principal Act, it is new as a standalone clause for regulations on penalties, but in part it's dealt with in amendment acts or the acts content in section 45 capital A, which we've already looked at earlier. We have received comments from PRASA regarding this clause, as well as Transnet. Going to the clause 67(1), Minister may, by notice in the Gazette, make regulations to provide that the regulator may, in respect of a person who fails to comply with any provision of this Act, including any railway safety standard or condition of a safety permit imposed in terms of section 31A, issue a compliance notice to the person so failing to comply, and B, determine a penalty in respect of non-compliance with the notice under paragraph A. 2, penalties imposed in terms of the regulations made under subsection 1 may differ between operators according to criteria prescribed by the Minister, may include provisions providing for the reduction of penalties in certain circumstances. 3. The proceeds of penalties paid in terms of or under this section do not form part of the funds of the regulator. The regulator must pay such proceeds into the National Revenue Fund contemplated in section 213 of the Constitution. 4. The regulator may recover penalties imposed in terms of regulations made under subsection 1 by civil action for disposition as contemplated in subsection 3. 5. Any person aggrieved by a decision by the regulator to impose a penalty contemplated in subsection 4 may appeal against that decision as provided for in Chapter 8. Considering the comments received here from PRASA, the input was here that section 67.2 states that a regulator contemplated under this section may allow for a differential penalty regime. The bill should make clear and indicate the grounds for such differential treatment and place the authority to determine this differential treatment. The department's response was that they would take guidance from the committee, but the differentiation is to be provided for in the regulations. So that is that portion of the clause that said that different operators may receive different penalties based on the circumstances and conditions. Looking at Transnet's comments, the department did not agree. Operationally, it's not optimal since the regulator must monitor payment of penalties. The regulator is monitored then in turn by the department as well as the Auditor General. Chair, then going to clause 68, regulations regarding safety critical grades and training institutions. This is a new clause, considering the old legislation did not cater for the training institutions and the setting of the specific grades for those institutions. We've received comments from PRASA regarding this clause. And that was the only comments received for clause 68. The department's, it was concerns regarding regarding duplication. The department did not agree with that view. Clause 68, the minister may, by notice in the Gazette, make regulations to provide for the licensing of persons employed in safety critical grade positions, including provisions on A, railway safety standards to be met for obtaining safety critical grade licenses, B, the post or job descriptions of persons who must be licensed, C, the registration of training institutions, D, criteria to be taken into account by the regulator when considering an application for the registration of a training institution, and E, information to be supplied in respect of the database contemplated in section 34(1)(c). So, Chair, that is part B on the regulations. For this chapter, we now move to part C, which is the transitional, repeal, and commencement provisions. So for clause 69, members will see the transitional provisions and savings as unique to each bill or amendment act. And we have received comments on this in general from PRASA, but that was on the training, the transitional arrangements regarding the current training institutions. The department did agree with the comment, but they also indicated that the minister will determine those. So looking at the clause now, 69(1), for purposes of the section, previous act means the National Railway Safety Act of 2002. 2, the minister must, within 1 year of commencement of this act, review all regulations or notices contemplated in subsection 3, and unless the minister within that 1 year period confirms by notice in the Gazette that those regulations or notices remain in force, such regulations or notices must cease to be of force or effect at the end of that 1 year period. Subsection 3, subject to subsection 1, all regulations or notices properly made or issued in terms of under the previous act remain in force as if they had been made or issued in terms of or under this act. 4, any cooperative agreement or arrangement concluded by the regulator in terms of section 6 2 of the previous act upon the commencement of this act continues to be valid as if it had been concluded in terms of section 7(2)(e). 5. Upon the commencement of this act, A, every person permanently employed by the regulator immediately prior to the commencement of this act is regarded as having been appointed in terms of section 24 of this act, without interruption of service and on the terms and conditions applying to that person immediately prior to the commencement of this act. B, every person contemplated in paragraph A remains subject to any decisions, proceedings, rulings, or directions applicable to that person immediately before the commencement of this act. C, any proceedings against the person which were pending in terms of or under the previous act immediately before the commencement of this act must be disposed of as if that act had not been repealed. And D, the board of directors referred to in section 8 of the previous act must continue to operate until the appointment of the new board in terms of this act. 6, upon the commencement of this act, A, all movable, immovable, and intellectual property of the regulator, including all financial, administrative, and other records of the regulator, and all documents in the possession of the regulator remain that of the regulator. B, the rights, duties, liabilities, and obligations relating to the regulator established in terms of the previous act remain that of the regulator. C, the regulator remains as a litigant in all pending litigation or proceedings. D, all valid and binding agreements entered into by the regulator remain binding on the regulator. And E, all funds of the regulator immediately before the commencement of this act remain that of the regulator. 7, all permits issued in terms of or under the previous act remain valid for the period indicated in the respective permits as if they had been issued in terms of this act. But for the avoidance of doubt, this does not exempt the holder of a permit from paying any fees due in terms of or under this act. 8, all fees and penalties due or charged in terms of or under the previous act are payable to the regulator on the date when they become due as if that act had not been repealed. 9, the minister must, not later than the date of commencement of section 34, by notice in the Gazette, publish a timetable in respect of persons already appointed to or performing work in a safety critical grade position at the time of commencement of that section, specifying the date by which such persons must comply with that section, but such a timetable may not extend beyond 2 years of the contemplated commencement of that section. 10, despite section 34(2) and 3, any person appointed to or performing work in a safety critical grade position immediately prior to the commencement of section 34 may, until the date specified in terms of subsection 8, perform work in a safety critical grade position and be appointed as such without holding a safety critical grade license. 11, section 38 of the previous act remains in force despite section 70 as if it had not been repealed until the date of the commencement of chapter 8 is fixed in terms of section 71(2). Chair, then going on to the repeal of law. Again, for 70 and 71, we received no comments. Repeal of law, the National Railway Safety Regulator Act of 2002 is hereby repealed. And then clause 71, short title and commencement. 71(1), this act is called the Railway Safety Act 2021. And comes into operation on a date fixed by the President by proclamation in the Gazette. 2, despite subsection 1, President may fix different dates in respect of different sections of the Act. Members will note, as we've seen in the past, obviously the date of the Act will change along with the date by when the Act is promulgated by the President. So, Chair, that is the bill. And the comments received on the bill for members' consideration before Chair considers our next agenda item. Thank you, Chair.
Thank you very much, Advocate. And we highly appreciate the mind and the time and the attention that you have paid in terms of ensuring that you capture all the submissions and where we differ. If I say where, because the bill is before us now, we differ, and also the a strong position of the department, as it were. Members, when we started, we did indicate that we don't necessarily need a quorum for this process. Therefore, I will urge that members, they do go to their various bodies or parties, if I may say that, or themselves, to be prepared when we engage in the immediate future on the bill that will be finalizing the bill. I will encourage that members of various political parties in this committee, when they make their submissions, where they agree, they indicate, and where they've got a contrary view from what the department would have said or the stakeholder that would have engaged even during our public participation processes, which public processes are threefold: written submission, oral submission, as well as the public hearings. They should indicate that, and where possible, submit it to the advocate through our secretary, so that when we come back, she would have a matrix that will indicate this was the original amendment bill that went out for public hearings. This is the view of the DA, for an example, of the EFF, ANC, or IFP, and I'm sure also other political parties would like to have a view. I will suggest that Honorable Stole, who, in terms of the arrangement of proportional representation in Parliament, does represent, lacking for a better word, the fewer, I don't want to use smaller parties because they get offended, but although if it's one, we are few parties, so that he can, however, if he doesn't, but it's well and good, so that when we come back, at least we are more focused to know that what went out for public participation, this was what, and then this is the views. And then with time, if we can do it at our earliest convenience, so that advocate, when we come back, then when she takes us through once more, we are clear which path that we need to concentrate on and seek convences to convene or to have some agreement or engagement on that, so that we can reach a proper conclusion in terms of the bill. And of course, nothing stops us to differ for this and agree that we differ on these clauses. But I will encourage that members in their caucuses or in their forums, I'm sure advocate won't mind also to be invited, where members, they think that they will fall short in terms of presenting to their caucuses the objective and actual clauses that they think that must be have a political guidance, as it may, noting that this is not a political process, but it is a bill. But however, we are from different political parties. Then I think on that, honorable members, you will agree with me that once more to thank the advocate and say that we have benefited. Other than that, I don't see any hand. Okay. Therefore, then that will bring us to point 2, which we were meant to adopt the minutes of our previous meeting. We don't necessarily have a quorum, notwithstanding that Honorable Jobe from the IFP and the ANC and the EFF are here, but we need 6 members. As we stand now, we're at 5, because Honorable Tito and Noluchungu, they are 2 in 1 in terms of voting purposes. Other than that, we don't. I suggest those minutes stand over for our next meeting when we correct. Our next meeting is tomorrow. Tomorrow, then I'm suggesting, because I was interacting with our committee secretary, that let's continue with tomorrow. The only item that will not reflect for the purpose of completeness is the bill. But we take today's, minutes and the report, and we see how far can we go on that. And I will encourage that all political parties do attend, so that at least we cover some spaces, because if we delay even adopting of our reports, for it to be 80 seats, it will be delayed. That will mean that it might remain below the line in terms of the NA Assembly rules until for the next administration. And I don't think that we want to engage and make our thoughts and our brains and our effort and recommendations to the department for it to remain just below the line. With that, honorable members, if there are no hands, it seems there are no hands for now. I will ask our committee secretary if there's anything that I would have omitted in terms of the announcement, but she shall do what she normally does later today to remind us about tomorrow's meeting. Honorable Secretary, sorry to say honorable, but you are honorable the way you do your work. It's honorable, it's much appreciated. Is there anything that I'm omitting?
No, Chair, you've covered everything. I will send out the links for the members just after the meeting, for tomorrow's meeting.
Okay, thank you very much. And also let me thank on behalf of the committee, the department which has ever been working this road with us. And you are most welcome still to log in tomorrow. It will be of benefit for you as well. Other than that, honorable members, I know we are at constituent period. We have received the permission, but you opted to be here. And we highly appreciate that. We are not taking it for granted. The meeting stands adjourned. Thank you so much. Bye.
Thank you, Chair. Manlanes.